All right, let's do this. Good afternoon, kids. I'm John Dyer, managing broker. This is the contract we're talking about. We're at the end. This is section 7 to the end. We will probably take less than an hour and a half. This is not the most complicated part. It's the fun part. It's the mumbo jumbo. It's the boilerplate, but it has a couple of things that are very important and very misunderstood. Let me start with my usual thing about contracts. You have a fiduciary duty to do perfect paperwork. That's not necessarily as easy as it sounds. I believe that every problem that happens in a real estate transaction is your fault. I don't care who does it, it's your fault. You have a duty to protect your client from all outcomes. You're a licensed legal representative. You are their guide through the minefield that a real estate transaction is. You must practice potentially paranoid, prepared, proactive problem prevention, and you do that with perfect paperwork. This contract is your hammer. Say you are a carpenter, this is your hammer. You need to know this contract as well as a master carpenter knows every tool they use, and certainly a hammer. 50% of licensed professionals will admit publicly they've never read this thing in one sitting. You should read it at least 50 times. I've taken a survey in classes for many, many years. A lot of you have heard this. And I ask a simple question. What percentage of agents are qualified to write a contract? And I love saying this, but it kills me. Based on 3 criteria. You've read it 50 times. If there's any recent case law, you can tell me about it, how it affected the contract. And if I ask you a question, you can tell me what section the answer is in. An embarrassingly low, humiliatingly low, disgustingly low threshold for qualification to write a document that you're legally allowed to write practicing law under Article 26. A very freaking big deal. My classes, not me, opinion of that for 20 years has been 2%. That's embarrassing. We need to know this thing like the back of our hands. If we don't, we're breaching our fiduciary, we're breaching our agency, we're not practicing risk management, we're putting ourselves at risk, we're putting our brokerage at risk, and frankly, it's completely unfair to clients for us to go out and make the money we do and them think we sell houses for a living, not understand that we're licensed legal representatives and a fiduciary, a position of absolute trust dealing with other people's money. Where do we deal with other people's money in the most significant manner? That's writing a contract. You need to know this thing like the back of your hand. If I ask you a question, you should be able to tell me what section and heck what subsection the answer is in. And my classes have said 2% through the years. This purpose of this class, it goes over and over. You do sections at a time, sometimes 1, sometimes 2, and then we start over, is to help you perfect your craft. We're on section 7 through section 9, through the end of it. Let's see, we start with section 7, remedies. My personal favorite, the cure notice. Cure period notice. Here's what it says. A party shall have an opportunity to cure a potential breach. Notice the word there, potential. Our contract does not have a breach. When you think of contract, I promise Jermaine over here, in writing, we make a contract, I will give him $5 for his lunch by the end of lunch. And I ate his lunch and don't give him $5, I've breached our contract. It's no more complicated than that. It's failure to keep a commitment. We work in contracts, so it's failure to keep a written commitment, which has legal consequences. We have potential breach, which is kind of a sweet thing. Let's talk about how we deal with potential breach. If a party fails to comply with any provision of this contract, the other party shall deliver to the notice of deliver a notice to the non-complying party specifying the non-compliance. If the non-compliance is not cured within 3 days after delivery of such notice, the cure period, the failure to comply shall become a real breach, an actual breach of contract. If the escrow company recorder's office closed that day, then must cure it, and it has to do with close of escrow, then the breach will roll over to the next business day. Once a breach is actual, it's subject to unilateral cancellation by the aggrieved party. I hate the cure notice. I think it's stupid. I think we're grown-ups. If you make a commitment, you should keep a commitment. The problem is agents weren't doing a good job explaining to clients what the commitment really was, and frankly, I don't think agents cared. and clients were losing earnest money and fights were happening because they were in breach and didn't even know it. Now they have to have a sign way to go, hey, hey, you're sick, you're in potential breach. You got 3 days, remember, a bunch of realtors and lawyers got in a room and screwed up counting to 3, 1, 2, 3, because the day you send it is day 0. You have 3 days to cure your breach, which basically means do what you promised to do in writing in the first place. There's nothing adversarial about this. There's nothing bad about it. The only bad act, the only negative act in a cure notice issuance is the act that caused it. One party failed to keep a written commitment within the time frame they promised. That is the negative act. The proper reaction is to say, dude, you promised you'd pay for your lunch. And then in this world, Jermaine would have to go, but I'll give you 3 days to pay for your lunch. And then at the end of those 3 days, I'm going to punch you in the face, because the agreement was if you didn't pay for lunch, I get to punch you in the face. That was our contract. I have 3 days to come up with $5 for lunch. Now, that's a metaphor, but it makes sense. Think about it. Here's what a cure notice is. And because I hear this all the time, it frustrates me. People talk about cure notice as being some adversarial in-your-face thing. Telling someone that they didn't do what they promised to do and holding them accountable, how is that adversarial? That's defensive and right. I have rights, you have rights. If you violate my rights, and I have the right for you to do what you say you're going to do in a contract, I have the right to stand up for them. People think a cure notice, so many people think in 3 days, I issued a cure notice, in 3 days the deal was dead. First misconception. A cure notice has nothing to do with cancellation. It has to do with the creation and determination and the transformation from potential breach to actual breach. Here's the metaphor that I use. And remember, metaphorically speaking, I mean exactly what I don't say, and I don't want any, anti-NRA Second Amendment. We're not talking guns for killing people or self-defense. We're talking guns in movies here. Because when you're watching a movie, and this is what a cure notice is, whether you can see the person or not, when you hear this sound, you know something could happen. They put a bullet in the chamber. Now, the important thing about that is, when you hear that in a movie, have any shots been fired? No. Is anyone dead yet or bleeding? No. Just the ability to potentially do that now exists. In a cure period, it's like a magic gun, because you put the bullet in the chamber that says, hey, do what you say or I can shoot you. But the trigger's not there. The trigger magically appears in 3 days. And then you have the full right, they've had their chance, they didn't take care of it, to basically shoot the deal. But until you pull the trigger, the deal is not dead. You can walk around with that trigger showing, that bullet chambered, and you can close the deal with a cure notice outstanding. Cure notice does not kill the deal. It simply gives the party who had a commitment breached and violated, who had someone else dishonor themselves by not doing what they promised to do in writing. And understand, a contract involves personal integrity and honor, and every buyer and seller should take it seriously, because when you sign a document, you're putting your personal honor behind it. You did not honor this agreement. I've given you 3 days. Thank you for coming through and honoring it. Or, hey, I'm not going to cancel the contract yet, but I can at any time, which, by the way, is extreme power for the aggrieved party, because the other party knows at any time you can pull the trigger on them. You can kill the deal. Bullet to the head, deal's done. That doesn't mean it's dead, but it's highly motivational. And if you're an agent, you have a fiduciary duty to protect your client, which means if the other party enters in a potential breach, you have a fiduciary duty to stop that nonsense as soon as possible. As soon as possible would be 3 days. How do you do that? You issue a cure notice, and at the end of 3 days, your seller or buyer, whoever's the aggrieved party, has the absolute right to cancel, but they don't have to. Failure to do so is violating your fiduciary, because you're actually protecting the other client from your client by letting them go on and on and on, and eventually maybe have a 3-day jerk the seller or buyer around period. There's no circumstance where you should not issue a cure notice. And people say my client didn't want to. That happens on rare occasions. If a client doesn't want to issue a cure notice, it's because you didn't do a good job explaining to them that the other party can screw them around as long as they want until you do. So, anytime someone doesn't deliver spuds in 3 days per Section 4A, issue a cure notice. That'll get them off their butt. If they don't deliver it in 3 days after that, the deal's not dead. But at any time, your seller gets sick of their nonsense, your buyer gets sick of their nonsense, cancel the deal, get your earnest money back. For a seller, if they do not deliver an LSU in 10 days, with lines 32 to 35 complete, yes or no, yes or NA, never no, issue a cure notice. Doesn't kill the deal in 3 days, but it means if they don't fix that within 3 days, which by the way is important because they don't have those boxes checked, they may not close, they're probably not likely to close, then you're protecting your seller in that situation. Your job is not to make nice and keep everyone happy. Your job is to protect your client. You are a legal adversary. Don't be adversarial, be nice about it. Say, hey, we didn't get the spuds, we're sending you a cure. Fix it. That's it. I actually have had people call and bitch at me because one of my agents sent them a cure notice, like somehow it's some personal insult to an agent. And they called me and said, why would your agent cure me? I said, well, first of all, I didn't know you were sick. Second of all, my agent's not Jesus or a doctor. He doesn't cure anyone. And second of all, he didn't cure you. He issued a cure notice, and we issued a cure notice against your client because your client didn't do what they promised to do in writing. Your client dishonored an agreement and violated agreement. There are consequences for that. There should be. One thing that people don't think about this contract is this is a matter of honor. It's a matter of integrity. You're signing your name to a commitment. I come from a world where a handshake meant everything. Now a handshake means nothing. Now contracts mean nothing. People sign this thing, they don't care. So what if I don't deliver a spud? So what if I don't do something I said I was supposed to do? It's just a contract and I can eventually cancel. There should be an emotional, intellectual, and moral motivation to do what you're supposed to do. And there should always be accountability if they're not. And guess what? Like it or not, when it comes to this, we're the cop. We're the accountability department. We advise our clients. If our clients are dumb enough not to issue a cure notice, listen to them. But you better be able to say I did a damn good job of trying to convince them because it needs to be done. Any questions?
LSU, you said after 10 days?
This first LSU must be delivered in 10 days per Section 2G, and it must have lines 32 to 35 complete. The pre-qual has to have lines 1 through 40 complete, but in 32 to 35 you can say no, which means they don't have it yet, or on the one in 10 days, the LSU must have yes or non-applicable. Either it's not a form they need or the lender has it. Because those are things that if they don't have in 10 days, closing in 30 becomes much less likely. It's a material breach. 95% of agents in town, maybe 99%, do not even know that the LSU now has a potential breach set to curing at like 32 to 35. Why? Because they don't know this document. And by the way, that's not something you should know. That's in John Dyer's list of that's something you can't not know. You're not doing your job. You're not qualified to do your job if you don't know that. If you don't know it yet, go read that section and learn it, know it like the back of your hand. Because that's how sellers actually are not getting earnest money they should. Sellers probably get earnest money 1/5 of the time they should. Because a buyer can't provide that, and 3 days later they haven't provided that or a loan denial, that's a buyer that's not going to close. They acted in bad faith. Your seller should get their earnest money. That's what a contract is. It's a commitment. Failure to keep your commitment has consequences. Completing your commitment has benefits. That's how it works. Positive, negative. Action, reaction. Now, Section 7B basically spells the definition of breach. In the event of a breach, the non-breaching party may cancel this contract and proceed against the breaching party for claim or remedy that the non-breaching party may have in law or equity, subject to the alternative dispute resolution in the case of the seller, because it would be difficult to fix actual damages in the event of buyer breach. The earnest money may be deemed estimate reasonable damages. Earnest money by assumption. This is not an absolute. By assumption, by practice, and in the vast majority of situations, is liquidated damages to the seller as fair compensation for taking their house off the market, losing marketing time, and basically being jerked around by someone who tried to do something they didn't have the financial wherewithal or the intent to complete. Okay? Like I said, sellers should be getting earnest money a lot more than they do. All right. And seller may at seller's option accept the earnest money as seller's sole right to damage, and in the event of buyer's breach arising from buyer failure to deliver the notice required in Section 2B, or notice buyer's inability to get loan approval due to waiver of the appraisal contingency per Section 2L. That's right. Failure to give notice of the appraisal within 5 days removes the appraisal contingency. And if they don't qualify because it didn't appraise, that's not non-qualification. That's an appraisal issue and subject to forfeiture. Seller shall exercise this option, accept the earnest money as seller's sole right to damages. An unfulfilled contingency is not a breach of contract. The parties expressly agree that the failure of any party to comply with the terms and conditions of Section 1D to allow COE to occur on the close of escrow date, if not cured after delivery, cure notice is subject to Section 7A, which will constitute a material breach of this contract, rendering contract subject to cancellation and forfeiture. If they don't sign documents 3 days prior to close of escrow, you must issue a cure notice without exception. And if they want an extension after you cure, fine. No extension should ever be given without earnest money being non-refundable. An extension is a renegotiation. Buyer's asking for something more. What are they giving in return? You want more time? Make your earnest money non-refundable. I see all the time people have deals extended 2, 3, 4 weeks. They never cure it. They never make earnest money non-refundable, and then 4 weeks later they get loan denied. And our sellers and clients are all pissed off. Well, you never issued a cure notice, and you gave them extension without making them put skin in the game in the form of their earnest money, in my opinion. If someone gets an extension beyond a week, they're sure they're going to close, they should deposit their entire down payment non-refundable. Do not let people jerk your sellers around. And when I talk about it, I see it all the time. It probably happens 80% of the time when deals cancel. They cancel in extensions. There was never any cure or any discussion of earnest money. Extension is not a gift. It's a renegotiation. Fight for your seller. Our contract is buyer weighted enough.
So you cure and you get earnest money. Seller gets earnest money, like all the earnest money?
No, the listing actually calls and we can get half of it if we want.
Okay.
Typically, and this is off subject, typically if they're going to keep the house on the market and sell it, then most agents will not push for their half of the earnest money because they're still going to get to make their commission, and they're letting their seller get a little spiff, which makes them like the agent better, and insurers are eventually going to get paid. If the seller's taking a house off the market or something, then absolutely, I'm getting my half of the earnest money. Yeah. Alternative dispute resolution, Section 7C. Here's what I'm not going to do is read all that. Basically, buyer and seller agree that disputes are not judicial primarily. They start with the arbitration process, and if things don't work out, there are situations where they can become true litigation and judicial. Hopefully that never happens. There's exclusion to ADR, and this is the important one, and that's if it falls under small claims court, Arizona Justice Court. That threshold is now $3,500. That is the seller didn't finish the repairs. Buyer had a moving van coming. Seller said, up yours, I'm not going to do them. Buyer had no choice but to close. Did a walkthrough, issued a cure, but was truly under duress because they needed a place to live, and the seller was taking advantage of them. It's $700. They take them to small claims court. That's not an arbitration. Alternative dispute resolution. That's how those are handled. And by the way, if you have a seller that refuses to do things at closing and your buyer has to close, I mean, most buyers by 3 days prior, the genie's out of the bottle, the bottle's broke. They need a place to live. They got a moving van on the way. They got a moving van in their front yard waiting to move the new people in. They got a landlord knocking the door and saying, your lease is up, get the hell out. Most buyers are in that situation. They have to close. Just make sure that you close clearly under duress, that you have the cure notice and the walkthrough out there, and then you go to court and say, I had no choice to close in spite of the fact that this SOB didn't do what they promised they were going to do.
I'm sure you don't remember, last summer I was in my second deal. I was helping some friends buy a condo for their daughter, and they really wanted it. They got a good price for it. They didn't for a good price, but they didn't fix the dishwasher like they said they're going to do. Most of the walkthrough. And so you had to cure them and you still closed. and that's what he says, you can take them to small claims court afterwards. But the seller's realtor was like, you can't do that, you can't cure us in closed, you can't do that. He was really upset with me.
Well, he was dead wrong.
I said, I'm just doing what my broker, 35 years of experience, has told me to do. So, but he was really upset with me.
Well, you know what?
I said,
If
you can't
I
do that. I
cure,
said, I've never heard of that.
if I cure for someone for failure to deliver spuds, and he gets right down to it, my buyer's like, I don't give a damn, let's just close. That's a good thing for the seller, because they could have been canceled at any time. I mean, you have a spuds that's not delivered, and you have a cure notice, you can sign loan docs and be about to record and go,
Yeah.
no, I decided to exercise my cure notice and cancel, which would be really nasty, but hey, that's called a lesson learned, baby. All right, so I paraphrase on ADR and exclusions. Bottom line is, you should read this 3 or 4 times. It ain't complicated, but it is something you should specifically read that section. 7E, just like any contract, attorney's fees usually fall on the person that loses. And I can't say it's always the case, because if you've ever read case law, there's absolutely nothing that's always the case. Otherwise, there wouldn't be so many innocent people in jail and so many murderers walking free. And we would have no more politicians, but that's a comment for another day. Section 8. Section 8 is how you get out of the military being crazy. For me, Section 8 is when agents write their own clauses, which makes me crazy. This is where you add additional terms. This is where you add things like an additional closing cost clause, because Section 2J limits it. Make sure if you're asking for 3% concessions, you're putting a clause in here that expands beyond 2J, because 2J is 1.8 to 2.2%. If you're asking for 3, I know 2 situations last week where buyers left money on the table, the agent was freaking out, that's their money. No, it's not. A seller agrees to a 97%. If they're taking 3% closing costs, let's assume it's a 100% deal, makes the math easy. They're agreeing to a 97% net. But they're agreeing to that net based on a budget for certain costs defined by the contract. Those are defined by 2J. The seller has a right to every penny that doesn't fall within that definition, because it's up to 3%. It's not a guarantee. If you're going to ask for 3%, make sure you put a clause in, like my acquisition cost clause, because that's all encompassing. And you really want to piss off your buyer, have them go to the settlement statement and realize that they're expecting $4,800 and they got $4,137, and they're going to want to know where their $663 went, and they will raise holy hell rightfully, because if you do that, that's not your buyer's fault. That's 100% on you. You have a responsibility to know every number, how it works, and to protect your client in every way. You're a fiduciary, a position of absolute trust when dealing with other people's money. Other things would go on here. Any additional special terms, any additional time frames you need, any requirements of the seller. Maybe it's a co-op, a weird deal, then it would be subject to receipt of articles of incorporation. Things like that. If there's any specifics, you have to put it on there. When you write a clause on page 8, remember to use John Dyer's clause writing methodology. TIMO, timing, intent, method, and outcome. Make the timing clear, make the intent of the clause clear, make the method of achieving whatever it is you're trying to do clear, and clearly define the outcome, which means what happens as far as cancellation and refund of earnest money or forfeiture of earnest money. Come to my clause writing class, we'll cover that.
So, in the writing, if you say 3% to go towards acquisition costs?
Acquisition costs, including all that. And you cannot list enough. Mine actually says and or outside of escrow by reimbursement at closing. So if it comes down to it, they can get reimbursed for their termite inspection, their home inspection. They paid $75 to have a roofer climb, whatever. Just make sure that there's enough there that if they ask for 3%, they can spend it. Rarely is that amount. That's more than 3%. But you want to ask for, you want to have a list that's larger than the amount you want, than smaller. Because if the list that you have is smaller, the money goes to the seller. If it's longer, the buyer just simply doesn't get it, but there's no negative to them because they're still paying what they agreed to, and the seller's still netting that magic 3% less. Other things on page 8 would be mandatory disclosures. If you sell a house to anyone who has a real estate license, top of that list would be me. I have a real estate license. I would have to put John Dyer's licensed real estate broker in the state of Arizona. Simple as that. If I'm selling to family, that would be mom, dad, brother, sister, children, grandchildren, and those of your spouse. So basically, you have stepkids or step grandparents, then that would apply as well. It doesn't go to cousins. I disclosed cousins last year or 2 years ago. God, time goes fast. I sold my niece a house. I simply disclosed the clients and niece of the broker. Nothing can come bad from it, but you must disclose. You and family members' failure to do so is a complete, the contract's voidable at any time for any reason. If you know from MLS that the seller's an owner agent, save them the hassle of countering. It's disclosed in MLS, simply put, seller's a licensed real estate in Arizona. So you're helping with their disclosure. It's mandatory disclosure. Everyone needs it in there, and that way you don't have to worry about a counter. Probably 1 out of 3 owner agent transactions I review, they forgot the damn owner agent disclosure. And let me tell you how bad that is. That's literally like rule number 1. People say, what's the big deal? I don't know, but it is a very, very big deal. You also must disclose professional financial relationships. So if you're in any way tied to an LLC that's buying the property, you must disclose that. If you're a partner in other LLCs, to the person who's buying the property, that LLC, that should be disclosed. You can't, it's physically impossible to over-disclose, really stupid to under-disclose. Better to pursue the impossible than live the consequences of the stupid. And it's old, like they say on the spuds, and that was the title of my class 20-something years ago, when in doubt, disclose. Anything else that would be pertinent, you would put here, okay? If there's additional personal property that won't fit in section 1G, put it here. Make sure you clarify what it is, and if you write different clauses, it's always a good idea to leave a couple or 3 spaces between them so you're clarifying. And that's about it for page 8, or section 8A. There's more to section 8. There's section 8B. Risk of loss. If there is a loss, excuse me, if there's any loss or damage to the premises between the date of contract, acceptance, and COE or possession, whichever is earlier, by reason of fire, vandalism, flood, earthquake, act of God, the risk of loss shall be on the seller provided. However, that if the cost of repairing such loss or damage, and by the way, the risk of loss would be on the seller. That's because section 5A says the property will be delivered in substantially the same condition. If it breaks after acceptance, it has to be fixed. The limit to that would be 10%. At that point, either party may cancel. And let me tell you, if you have a pretty good fire, it's usually more than 10%. I've seen it go both ways. I've had 2 houses burn, one pretty much burned down in escrow. In one case, it was the one that pretty much burned down. The buyer decided to proceed, accepted an assignment of the seller's insurance, and they were pretty much going to remodel. So they went from a remodel to a strip, and it worked out great for everybody. The other one, the buyer needed a place to live, and the house didn't have a kitchen anymore because that's where the fire was. And by the way, the most expensive room in most houses is the kitchen. It was definitely 10%, and they had to cancel. In one case I got paid, in the other case I did. I've actually had another house burned down, but well, I had it listed. I probably shouldn't say that because people, if I go to list their house, you're gonna be like, dude, I want you to take my house. Your listing's burned down. Statistically speaking, the odds are down. I've had a few listings. All right. This is huge. Notice 394. Buyer and seller grant brokers permission to advise the public of this contract. Does it say what part of the contract? No. And anywhere in this contract does it say it's confidential? The terms are no. Are buyers and sellers' names confidential? Absolutely. Are the terms of the contract? No. Which means if you have an offer for $200,000 and you get a backup, you got other people calling on it, you haven't accepted that offer yet, you can tell them exactly the hell what the offer's for, shop it, and hope for more money. It's not wrong. You actually have permission in the contract. Yep, it says this contract, which means if you're disclosing the contract, that would be disclosing the terms, except for that which is confidential, which would be any financial information on your client and or their names. Besides, who wants to give your clients' names out anyway, because that's just stupid.
So it's not a fiduciary, they don't have to, I mean, because
Unless your client tells you not to. If your client says, don't disclose this. I always ask my clients permission, hey, we got like 19 phone calls since we got this offer an hour ago. Permission to tell them what the offer is, and I'll get you more money. What seller say yes? I always ask, because under the carload, we're bound by obedience. We can only do what our client tells us to do, so I would need those instructions. But one thing that those instructions, I've had people say, you can't tell other people what my offer is. I'm like, show me the confidentiality clause in the AAR, Real Estate Purchase Contract of 2017. Ain't there. Is there a really good argument it should be? All the terms of this contract are confidential until close of escrow and even pending acceptance, yeah, but it's not in there, so let it win. And this is no brainer. This contract is governed by Arizona law and sent to Arizona courts. Surprise. Time is of essence. And what that really means is now's too late. Okay? Compensation. I'm going to read this. I don't like reading it. I like to paraphrase it, but everyone wants to argue it. Seller and buyer acknowledge that brokers shall be compensated for services rendered as previously agreed by separate written agreements. Stop right there. Never, ever is there any change to a commission or commission in any way referenced in a purchase contract. This is between buyer and seller. We are paid by the listing agreement or buyer-broker agreement. Contract acceptance is the final stage of our payment, but our payment is paid under separate agreements. I saw the other day that buyer-broker will reduce commission to X in the purchase contract. No side agreements written by anybody, and the buyer-broker, the listing broker, and they all signed it and thought that was binding. That buyer broker could have walked into closing and say, I never agreed to that. You show me in writing where my broker signed a reduced commission, and that would be done. You don't reference yourself in a contract. We're not a party to the contract. We don't want to be a part of the contract. If you have a buyer broker fee, that's a balance due. You don't reference yourself as a commission in a contract. You reference yourself as a buyer broker a buyer closing cost. All right. Which shall be delivered to buyer's title company, escrow company, for payment at COE. Basically, you're listing your buyer brokers an invoice, if not previously paid. If seller is obligated to pay brokers, this contract shall constitute an irrevocable sign of the seller's proceeds. We get paid at COE. If the buyer is obligated to pay, payment shall be collected from buyer's condition of COE. Here's the deal. Commissions payable for the sale, leasing, and management of property not set by any board or association or multiple listing service or any matter other than between broker and client. Notice it doesn't say between broker and broker. If someone's offering a co-broke you don't like, you cannot call and ask for more. The contract is determined between them and their client. If you don't like what's in MLS, get a buyer-broker agreement or take what you're given. Co-broke is an entitlement, it's a gratuity, and per this, it's negotiated between you and your client or the seller and their client. If you're stupid enough not to have a buyer-broker agreement, then you got to take whatever that seller and that listing broker decided to give you. Period. End of discussion, no argument. HG.
So wait. If you have a buyer broker that says 3%, you can't call the seller broker and be like, hey.
You can call seller broker and say, I have a buyer broker agreement negotiated between my buyer for 3%, because you're talking about a fee negotiated between you and your buyer, the same as they're offering a co-broke through MLS. That you can talk about the co-broke in MLS because it's offered and there's a written agreement behind it. The buyer broker can call and say, I have a buyer broker agreement. That doesn't mean they have to pay it, but you can definitely say that because you have an agreement giving you this much. Understand the difference? Yeah. And that's where people get lost.
In other words, you have to have that signed before you can actually talk to people.
All right, I'm not going to read section AG because it's so simple. Copies and counterparts. Any document can be signed in counterpart, and it's very simple. Say I have an addendum, changing the close of escrow, and Mrs. Buyer is in Pennsylvania, Mr. Buyer is in Jamaica, Mrs. Seller is in Washington, and Mrs. Sellers, they're really lucky when she's in Switzerland. You can get 4 different addenda signed by one person, you put the 4 together, and you have a fully executed addendum. That's what counterpart means. There is one exception to that. Everyone's favorite document. Per federal Environmental Protection Agency law, a lead-based paint disclosure cannot be signed in counterpart. Period. Hey, we're lucky they let us get digital signatures. All right, days. All reference days include a calendar shall be construed as beginning 12 a.m. midnight to 11:59 p.m. I'm not sure where that last minute went, if we're ever going to get it back. I figure we're losing an hour every 5 years. That's my calculation, but who am I to do math? So every 5th year you have an extra hour to get a contract accepted. No, just kidding. What that means is if it's not a day, it's not a day. If it's from 12:07 a.m., if it's 12:07 a.m. till midnight, that day doesn't count. It has to be a full day, which is where I talk about day 0. The day a contract is executed does not count as a day because part of it has already passed. Tomorrow is day 1. You always count day of acknowledgement, day of the beginning of the inspection period, day of the beginning of response period is day 0. So basically all of our days have a day added. Entire agreement, McNugget clause, okay? Any parts you put together shall be considered all in one, which is why it's very important to number your addenda, to clearly define on your counter the contract date, and make sure there's a clear reference tying any ancillary documents, exhibits, supplements, amendments you may do specifically to the contract. Then once executed, they are considered a part incorporated into the contract.
So, on a or say on an addendum, it'll say when was the purchase, or when was the contract, or the contract date. Do you put it for the purchase contract or the counter contract or the counter offer?
The contract date
So
is the date it became a contract, is the last signature required to make it fully executed. So it's if the seller signed the contract, it's the date of seller signature.
Okay.
If there was a counter and the buyer signed a counter, it's that. If the buyer counter, if you go on counters for 9 days, what date you actually have a contract? Is that 9 days later when you finally get through it. Ready for this? I can't believe this. You know, I always say I think I've seen it all, and I won't ever say that again. I saw a new record. The previous record I saw was 9. I saw a contract with 12 counters. Okay, I'm not going to tell you what to do, kids, but if you get past 4 counters and you're still dealing with structure like prices, you're not just clarifying, hey, you forgot to initial line whatever. 4th counter to keep, that's a good thing. After 4 counters, you might want to consider tearing up and starting over. And I'm saying that to you for title companies, because they're the ones that got to figure out, okay, this made that go away. But no, wait a minute. This put that back after that made it go away. But wait a minute. Well, this put it back part way after that made it go complete. That's literally what a counter is. It's taking parts away and putting them back. It gets very confusing after a while, and I've seen them where you know, the title company raised a question, and what they did was they took it out, they put it back, and then they took it out again, and then they put it back, but they put it out different than they took it back, so it was still out, but it wasn't in. I mean, it's just, you got to be careful. Look at that. That hurts.
Paintball?
All right. Yeah, go ahead.
Was it paintball?
Pardon me?
Paintballing? What is?
No, IV. Oh, look.
Yeah.
It was like, I was either in the hospital or I had a good week in the alley behind the dumpster, right? I wasn't in an alley, let me put it that way. All right. Entire agreement. We already talked about that. Subsequent offers. Seller can take as many backups as they want. I have seen offers where the buyer says the seller agrees to take no backups. A seller is an idiot to ever agree to that. Backup offers only mean absolutely nothing to the previous buyer unless what? They don't perform, and then who can blame? Backup offer is plan B. I want on my epitaph, I want on my gravestone when I die. The one thing I'm proudest of. John Dyer, he always had plan B. I mean, who the hell wants to go through life when plan B doesn't work going, now what I do? And if you know me, I'm better off going through life with plan, I don't know, LMNO. You know, my first efforts tend to be a bad idea. So, no, they can have as many backups they want. If you take more than one, make sure they're numbered and disclosed and everyone knows where they stand.
Well, so what do you mean by they have first and right if they? What do you mean by where they stand? Like, why does it matter?
That you keep a good record of when they came in, who came in, which is which, and everyone knows they're a backup offer. And if you're accepting them as backup offers, you need to accept the backup offer. Say that you use the contingency. The additional clause addendum. The clearly defines what a backup offer is, so everybody knows where they stand. If I write a backup offer and they say they're going to accept another one, but mine's the best backup, I want in writing that my backup is first. So that if the first one falls through, I get first shot, and then if I fall through, then they go to the other one. Because sometimes people take multiple backup offers and give them, so once the first deal falls through, then they get to go back and pick up the one they want. Or they don't specify, then you have a legal issue as to who wins. The legal concept that would prevail is first in time, first in line. But I don't want to go to court to prove that my backup offer was in first and accepted first. I would just rather have in there that my back offer is first and best, it's more money, it's your favorite, good. Then you put in writing that in the event that one dies, I go first.
Oh, in other words, so a backup offer, the seller still has to agree to take it.
No, if there are people that are dumb enough to accept, for a seller to accept 3 or 4 backup offers, just tell them they're all backup offers, but not tell them where they stand. And then the first deal falls through, and they'll come back and say, get to buy the property, and the listing goes, no, because your backup offer was lower in second. It's full disclosure issue, and you're setting your seller up for legal liability.
Okay.
So like I said, just make sure everybody knows where they stand, it's in writing, and if you write a backup offer, make sure it clearly states that your backup offer is in first position, and if you don't decide to exercise and go on, then they can go on, but if you do, you're there. All right. Cancellation. A party who wishes to exercise a right of cancellation as allowed herein, no, it's as allowed herein, may cancel this contract by delivering notice stating the reason for cancellation to either party, ready for this, or to the title company, and to the other party, or to the escrow company. Notice, everybody thinks it has to go to the seller, or either the other party or the escrow company. Cancellation shall become effective immediately upon delivery of cancellation notice if it's within the rights of the contract. For example, they didn't deliver spuds. I cured them. 10 days later, I've had enough. I send notice of cancellation to the title company. The deal is dead. Period. Okay? No dispute. If it's my seller saying, which happens all the time, this is really bizarre. In my first 30 years in the business, I saw 2 times, in all those years, where a seller said, I'm not closing. In the previous 10 years before coming here and getting back to reviewing documents and dealing with broker stuff with other companies, I saw it twice, including only once at a company that did $15,000 deals a year. We have 1 or 2 sellers a month who just go, nope, changed my mind. Make sure you understand what seller needs to know if they change their mind, don't want to close. First of all, the first thing you say is, I'll see what I can do, but the minute you cancel, you have to write my home group a check for the entire commission, because I owe the other person a co-broke, because commissions are earned upon delivering a ready, willing, and able buyer and accepted contract. They're earned when the contract is signed. They're payable at closing, or per our listing, they're payable at closing or cancellation initiated by the seller. I said that in a class the other day, and someone said that cannot be. I said, how else can it be? And they said, well, how can a seller get out? It's real simple. They can't. Buyer has contingencies. What's a seller contingency? The only way out of a contract without suffering damages is have a contingency. A buyer doesn't have any contingencies and they walk, what happens? They lose their earnest money. A seller doesn't have a contingency and they walk. First of all, the buyer's been damaged. They took time out of their life. They may paid for a moving van. They got paid for an inspection, probably an appraisal, and they owe a commission. That's consequences for failure to commit. But you want to get their attention as soon as you say the buyer's And we've had it happen in the last couple weeks. A buyer filed a list pending. It's good. You don't sell it to me. You can't sell it to anyone. And in the meantime, when they realize they got a Ryerson check, you'd be surprised how fast sellers go.
Echo that.
You know, on the other hand, maybe I do want to sell this piece of property. We had one, it's one of the most amazing things I've ever seen, and the only once I've ever seen this in my entire career. Seller canceled, refused to back off, wrote us a check for, I think it was $17,000, and said, let the buyer come after me. Like, okay, we'll take a commission for not selling a house. It's not how we prefer to make our living, but if you're going to put yourself in that position, that money spends the same as any other.
So they gave the money, but the buyer can still go after the seller for.
Yeah, what happened with the contract between buyer and seller? They breached the buyer, but they also violated the term of the listing. We collected on the terms of the listing and then told them, we can't help you with it. You know, you understand this buyer's coming after you too. And they said, I don't care about the buyer. I got lawyers, but they knew they actually had no case to defend against us. But we have a listing that says, in the event of seller cancellation, blah, 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 they owe commission. That's a class for another day. All right, notice. This is so important and so buried in the contract. Unless otherwise provided, delivery of all notice of documentation required or permitted hereunder shall be in writing and deemed delivered and received when hand delivered, sent by fax, sent by electronic, email addresses provided herein, sent by recognized overnight courier, etc., and addressed to buyer as indicated in section C, to seller as indicated in section, or to the title company as indicated in section 3A. Basically, you got to have evidence it was delivered, or no one ever got it. Notices. A&N release of brokers. I don't read broker hold harmless clauses. The reason these are in a contract is so the judge will have a place to doodle while we're being sued. I say this all the time. I challenge someone to find a bit of case law. I've read a lot of it. I've never seen a bit of case law where the judge said, oh wait, I found a hold harmless clause. Broker, you're off the hook. You're not getting sued. You get your money. It doesn't work that way. Terms for, we do require signatures on 434, by the way. Terms of acceptance. This offer shall become a binding contract. I wish it said legally binding. Should become a moral obligation. I'm in a soapbox here. When I started in this business, people who had to not close a deal for any reason were horribly apologetic. Even if they had a contingency upon loan, they felt like they had made a commitment and they failed at their commitment. It was a moral burden on them. What the hell happened to that view? What happened to our world where people don't think like that? I had a back door and I used it, F you. I mean, that's just, come on. There should be honor in everything, but certainly in contracts where you're tying up someone's largest asset and potentially offering them their largest check they're ever going to get. Oh, I changed my mind. I don't care. I had a way out. I don't know. That's a sad statement in our society that nobody gives a damn. You should at least feel bad. I'm sorry I took your house off the market for a month and the prices dropped 3%. I'm so sorry. I feel bad. You should feel bad. Someone else's life sucks because of you. You didn't do it on purpose, but you still feel bad. It's called morality. It's called humanity. It's called get a freaking clue. All right, this offer become a binding contract when acceptance is signed by seller and a signed copy delivered in person by mail, facsimile, etc., and received by the broker. Okay? Understand, an accepted contract is considered to have met the final stages of contract, which is acceptance and delivery. That's what this is about. We are the receiving agents. When we have it, as far as the law is concerned, our client has it. That means, and that's true of most documents, that means you cannot sit on a document. If you get an accepted contract at 9 o'clock at night, you need to forward it to your client at 9:01 at night. And you put the time frame, that would be by how long do you give someone? Here's the deal. You want an answer now. and you got multiple offers, it doesn't matter. You can put time for acceptance 5 o'clock. Here's what they're going to call and tell you. We have 9 offers. We will be making our decision Monday at 5. And you know what? Give them time for acceptance Monday at 5, because all you're doing is having your contract expire before you know they're going to get around to it. I had someone say, oh, well, they said Monday at 5, and I gave till 5 today, just to push them. I'm like, all they did was laugh at you. They got multiple offers. All you're gonna have to do is go back between now and Monday and extend your acceptance date. Legally, it's a thing called duress, and it would be defined as you need to give someone chance before entering into a legal document. We need to advise our clients that the other party and them should have a chance to get legal counsel, which means it would have to be 5 o'clock the next business day, because law offices aren't open on the weekend. Obviously, play to win, but don't push it. And I've had people say, I always give 2 hours for acceptance. Like,
so after it expires and the seller agrees to accept it, or the buyer,
then you have to go back and do a document that extends the exception period. Otherwise, the seller's accepting an offer that no longer exists, because upon expiration, it's like it was never written.
But what if it does happen? What if we just continue to go?
Sometimes they close like that, but it's absolutely a potentially voidable offer, and it means the agents didn't know what they were doing. So, because literally, when that time for acceptance passes, just soon burn it. This contract never happened.
So
if it's not, this offer ceased to exist, and the contract never happened if that acceptance time expires.
Could that be a backdoor for both parties, or just one party?
It's a weasel clause. It's a weasel clause for the seller primarily, but it could be for the buyer. In other words, just don't put yourself in that position. And yeah, I have people say, I give everyone 2 hours. Like, 2 hours? That's a long lunch. You're going to send me an offer at 10 o'clock, acceptance at noon, and expect me to take you seriously? No. Give me time. Be reasonable. Be fair. And the time of day, AM or PM, obviously it's Mountain Standard Time. Buyer may withdraw, this is important. This offer any time prior to acceptance. If no signed acceptance is received by date and time, this offer shall be deemed withdrawn and earnest money returned, because we're supposed to be holding, okay? When they don't accept it on time, the contract is written so that if I haven't got acceptance by 5 o'clock this afternoon at 5:01, it's the same as if I sent an email saying we're withdrawing the offer. And a buyer can withdraw any offer, a seller can withdraw any counter, a buyer can withdraw on any counter prior to execution, acceptance, and delivery. They call and say, hey, my seller signed it last night. Yeah, but you didn't send it to me, and we withdrew, so we didn't have a delivery. Because remember, the final stage is delivery. That's why once you have something signed, it gets to the other party in light speed, real time. In my old days, that was literally a day or two, because everything was driven, mailed, or hard copy. Unfortunately, today, what is real time? 17, 18 seconds. Drag it over here, open, make sure it's right, and forward it to the listing agent.
You said we're supposed to be holding the earnest money?
Yeah, the assumption is, yeah. You went to real estate school, Ernst. That's made out the title.
So not to touch.
I don't want to touch a check. That's why you check wire transfer. Checking wire transfer on this thing, which scares me with wire fraud, that's prima facie evidence you don't have in hand, because there's no such thing as a real estate broker that has a wire transfer machine. If there is, I'd love to meet them and understand why they did it and how they pulled that off. All right, basically this is the standard. This contract is 10 pages. They're all important. You better know them all. If there's any addenda, that's a part of the contract and equally as important. Section 8Q, broker on behalf of buyer. There's now a place for 2. Reason there is, we have these teams that may have an agent who's the buyer agent. The real deal's in the name of the team leader, and we used to have the team leader's name on here, and everybody was talking. The buyer's agents are, well, why your name on here? You haven't had a single conversation during this conversation. We added another one to accommodate that. Put in your agent code. Put in your license number. Okay? Put in your telephone number. What's a fax? The word fax itself is so last millennium. And your email, your business email. I have 3 emails. Nothing screws my day up more when someone asks me for my email and I give them the wrong one for that purpose. I have a Yahoo email, which is if you're gonna send me stupid jokes or, or pictures of people, vomiting and all the weird, horrible things friends send to people that you don't want to see, that's where that goes. If I sign up for anything just to see what it's like, 30-day trial or something, they get that email. I have my school email and I got my home group email. Most people have multiple emails. If you don't have a business specific email that you do nothing with real estate on, you need to have one. You should not be mixing your real estate with your personal email, and here's why. Like I said, I have friends send me just horrible things. Horrible people, humorous as hell, but horrible. And I have communications with my family members, and communications about friends who are in distress, and we cry together over email. And then I have my purchase contract and I get sued. I want to be able to say none of my business is on that email because that email would be subject to subpoena, and I don't want some hack at the law firm of Dewey, Bentham and Howe digging through my private life, although he'd probably get a kick out of the horrible, stupid things my friends send me. Okay, I'm talking about Johnny Walker, by the way, but that's a story for another day. No, yeah. You need to have a business-specific email. Okay. Agency confirmation. Now, you should already have an agency disclosure. If you represent buyer, you should have lines 34 and 36 checked. If you represent seller, you should have lines 41 and 42 checked. Right here, if you're representing the buyer, you check 34 and 36, you check buyer. If you're doing an unrepresented buyer, which is rare, but it happens, you would have a buyer agency with the rare time you have line 35 checked, and then you would check seller on here. If you're doing dual agency, which means you damn well better have 34 and 36 checked for the buyer and 41 and 42 checked for the seller, because 36 and 42 give you pre-permission to do dual representation. This is the third stage of agency confirmation. You would check both buyer and seller, and that would require consent to limited dual representation.
I didn't know you checked both of them.
What?
I didn't know you checked both boxes.
Absolutely. One says I represent the buyer's broker. The other one says I can show buyer properties listed to my broker. If you check 34 without 36, you cannot. You get written instructions not to show any of my home group or your own listings. If you're a lister and you check 41, it says represent seller, seller's broker. If you don't check 42, you have written instructions from your seller that no my home group agent can ever show or sell that listing. Because an agency disclosure is written instructions. Take it seriously. And some people check all three boxes, which means you're literally, only thing you can do is you can only sell the property under dual agency, which is extremely limiting. If people would read the form, it's a no-brainer. By the way, I reject 40% of agency disclosures. It's the form where you're just, it's like complete ludicrousy how bad we are on that form. Okay, place here for buyer's signature, buyer's name printed. Make sure when you do page 1, section 1A, that you ask the buyer how to spell their name and how they want it legally recorded. Title will take the name to go on their deed, a pretty big deal from this document. And then reiterate, make sure when you send it to them, one thing you want to check, say check your name. I'm John R. Dyer. It's John R., right? Because if you leave out the R, it can cause problems. Have them sign it, make sure their signature matches their printed name, other buyer signs. Address, city, zip code, that stuff's good. It's not required. Some people take exception to giving the listing agent the buyer's address. If your buyer doesn't want their address to go to the listing agent, that's up to them. It's not your call. It's none of your damn business. That's between the buyer and their confidentiality. If they want the seller to see it, they see it. The only way you can make that determination is ask. You can't go, well, I never put the buyer's address down there, because that means you're thinking for the buyer, which is a breach of your fiduciary. Ask the buyer. Do you want your address and stuff on there? Let me tell you what most buyers are going to say. Hell no. I don't want the seller and listing agents to know where I live. That's silly. Then you leave it blank. Section 9. Listing agent. Same stuff. Fill it out completely. Get your firm name right. Get your firm address. Put that all on there. Okay, excuse me, the seller's firm address. And that's really easy because if you're not using MLS Connect, you're kind of wacko, and that'll take care of it for you. Okay. Seller printed name stuff. That I check section 9C on line 1B and let the listing agent fill that out because I do not want to be responsible for how the seller spells their name, misspelling their name. This sounds kind of ridiculous. I review 3 to 5 counters and addendums a month, and sometimes addendums done at closing to close, correcting the seller's or buyer's name or spelling. Make sure you get that right. Really embarrassing. Oh, we could have recorded it for, but we have to correct your name on the contract because it doesn't match the deed or anything else because I misspelled your name. That's an embarrassing moment. Any questions? What time is it?
It's merged deed. 402.
Cool. I didn't think it was going to take a whole hour and a half. All right, thanks guys. We're done. I will tell Kelly to turn the thing off. We'll see you in 2 weeks, which is, by the way, I believe it's addenda. I believe in 2 weeks we're going to do a cursory of all addenda, and then we do the listing, the ER, and the buyer broker and employment agreements, and then we probably will start the contract again, I'm guessing, in beginning of June. Or, yeah, because it's going to take a couple weeks to do listings. So we'll go rotate and do it all over again. Thanks, have a good one. Kill it, Kelly. I don't know how to kill it. Unplug it.